Ladies and gentlemen, welcome back to the IndieZoNe podcast. My name is Kathy. There has been a development in the matter styled as State of Idaho versus Brian C. Kohberger. The trial court, Judge Stephen J. Hippler, has released a number of previously sealed documents to the public. These are documents from April and May of 2025. So in order to find them, you have to go to those months. And there are little notifications next to them, new, indicating that these, although they're dated in some instances the better part of 6 months ago, they have just been released to the public. Several of them from April and May of 2025 were proposed jury instructions. Now, what is a jury instruction and why is it proposed? Well, it's proposed because the court is the trier of the law who may make decisions based on law. In other words, if this proposed jury instruction being offered up by the state or the defense meets the criteria that the court believes that it should have in order to meet all requirements of law, the court would likely then go ahead and approve it. The court doesn't have to. The court could disapprove of something, ask the parties to go back to the drawing board and resubmit, or could make some changes as the court felt was necessary in order to ensure that the proper standard of law was being communicated to the jury. Jury instructions serve an important role in a trial by jury, which is what Idaho versus Kohberger was headed for prior to the change of plea hearing on July 2nd, 2025. The parties were just weeks away from voir dire on the 30th of July, which is the process of the commencement of trying to find impartial jury members to be seated as the jurors in the case, with several alternates in the event that someone would need to drop out or was excused for some reason. Sometimes it happens because of an unexpected illness, for example. Jury instructions are read by the court in open court to the jury panel, and it is intended to educate the jury on important matters of law, such as what does beyond a reasonable doubt mean? What is the presumption of innocence? What is the jury's role as the finder of fact versus the trial court's role as the trier of the law? Jury's role as trier of fact is to determine, to put weight based on the presentation of the evidence and decide whether, for example, disputed findings of fact could be something like, was suspect vehicle 1 Mr. Kohberger's car, as the state was arguing, or was it not Mr. Kohberger's car, as the defense was arguing? That would be an example of a disputed fact that only the jury could make a final determination on in the quest to hopefully reach a verdict. Sometimes jurors, after they deliberate, they can't reach a verdict, and there is what's called a hung jury, and then in many cases a new trial has to happen, start all again from scratch. The jury instructions are read to the jury after the conclusion of the case in chief by the state and any defense that the defendant would have offered up. Then the court reads the jury instructions. There may be many in a case. There may be just a few. And then the jury retires or goes in to the jury room for deliberation. We're going to be going over these jury instructions in the first upcoming episodes of the IndieZoNe on our sister YouTube channel. We have a link to it in the description to this podcast episode, and ask that if you have not subscribed, please do, because unlike here where the podcast is only audio, we do visuals and we go over documents such as jury instructions. So please be sure to subscribe and hit the notification button so that you will be notified when our new content hits our YouTube channel. This will now conclude this episode of the IndieZoNe. Thank you for joining us here today.